It's only just over 11:30. Our apologies. There has been confusion about whether or not we are commencing or resuming today or tomorrow on the part of one member of the tribunal. But upon realizing that we are resuming today, he tried his best to arrive in time. And I told you in chambers that he said would arrive between 11 and 11:30 because I was coming to Pretoria. So indeed, he has arrived in time. So we are resuming today, and Council can assume that in making their submissions that we have read their written argument, and that as and when they begin with their submissions, they must do so against that background. They are free to argue the matter in the way that they prefer best, whether to highlight certain points and which ones and so forth and so on, as long as they understand that we have read their heads of argument. Advocate Skippers.
Thank you, Chair. Chair and honourable members of the Tribunal, this Tribunal has been convened pursuant to the determination of the Judicial Conduct Committee, which found that a prima facie case of gross misconduct exists against Judge President Selby Mbenenge. The establishment of this tribunal is therefore not a mere formality, it is a constitutional imperative. The task before this tribunal goes far beyond administrative inquiry. It represents a crucial test of the judiciary's integrity and its commitment to the foundational values of the Constitution, which is dignity, equality, and accountability. The outcome of these proceedings will speak to the very heart of public trust in the judiciary. It will demonstrate whether our system of justice has the courage to hold even its most senior members accountable when confronted with serious allegations of misconduct. The central issue in this matter for determination is clear: whether the conduct of the Judge President constitutes sexual harassment and whether that conduct amounts to gross misconduct within the meaning of the Judicial Service Commission Act and the Code of the Judicial Conduct. It is common cause that the respondent, Judge President Mbenenge, sent sexually charged WhatsApp messages and unsolicited images to the complainant, Ms. Andiswa Mengo, a judge's secretary. The defense advanced by the respondent that he misread signals or misunderstood intentions does not withstand legal scrutiny. The proper test is not his subjective belief, but an objective one, viewed through the eyes of a reasonable person. Did his conduct breach the Code of Judicial Conduct, and did it undermine public confidence in the integrity of the judiciary? If we look at the evidence of the complainant, what emerges from this body of evidence is a deeply troubling pattern of behavior. It was persistent and unwanted and inappropriate advances from a senior judicial officer towards a subordinate employee. The implications of such conduct go far beyond the personal. They strike at the principle of equality in the workplace, the right of women to dignity and security, and the constitutional expectation that judicial officers will embody the highest standards of ethical behavior, both in and out of court. The complainant, Ms. Andiswa Mengo, provided detailed testimony. She described the discomfort and emotional distress she experienced as a result of the respondent's persistent advances which she repeatedly attempted to deter. The WhatsApp messages corroborate her version. They show that the respondent initiated the majority of the conversation, steered them from neutral topics to sexual themes, ignored attempts to disengage, and even sent unsolicited sexual images. The complainant never initiated intimate discussions. She used politeness, humor, and silence to deflect discomfort, not to invite it. She eventually blocked the respondent in an attempt to maintain professional boundaries. Her testimony reflected not only distress, but the heavy burden of navigating an unequal power dynamic. Her account found support from several witnesses. Importantly, she testified that she initially refrained from lodging a complaint due to fear of retaliation and the respondent's seniority. She only later reported the conduct to the court management, sought mediation, and only escalated the complaint when informal processes failed. These are not the actions of a malicious accuser. They are the careful, hesitant steps of a woman balancing fear, duty, and integrity. The digital forensic expert, Mr. Moller, confirmed that he downloaded messages from the complainant's handset. He testified that the deleted messages are irretrievable due to the fact that it was overwritten. But the fact of deletion itself is significant. The complainant preserved the messages on her device. The respondent did not. A crucial aspect of his evidence is that the absence of messages due to deletion does not mean the content never existed. This is especially noteworthy in cases of sexual harassment, which often occur in private and are seldom witnessed. Dr. Zakira Dokrat, the forensic and legal linguist, provided uncontested expertise in social linguistics and the semiotics of emojis. Her analysis showed a clear escalation in tone, from professional exchanges to overtly sexual communication. The respondent's messages employed explicit emojis, for instance, the eggplant, the peach, and the licking lips, universally recognized as sexualized symbols. The complainant's laughter and see no evil emojis reflected discomfort, not complicity. She testified that context is paramount. Emojis cannot be interpreted in isolation. The meaning depends on the conversation flow, cultural background, and the relationship between the sender and the recipient. Under cross-examination, Dr. Dokrat was firm. Viewed objectively, these messages could not plausibly be construed as platonic. Her findings align perfectly with the complainant's account that the messages received from the respondent were unwanted. Ms. Kutlwani Moretlo, a former state law advisor at the JSC, was instrumental in formalizing the complaint against the JP. Her evidence provides procedural certainty and institutional legitimacy to the manner in which the complaint was lodged. She testified that on the 7th of December 2022, she assisted Ms. Mbenenge in the drafting of the complaint, carefully recording her narrative and cross-referencing WhatsApp messages for accuracy. When the process could not be completed that night, the draft was saved to a memory stick for finalization. The next day, the document was returned by Ms. Mbenenge, printed, signed, and properly commissioned on the official JSC platform. Ms. Moretlo explained that although the original complaint was later misplaced after being handed to the Chief Justice, it was never rejected or deemed inadequate. The complainant was simply asked to resubmit it in affidavit form with clearer references to the messages. This second reformatted version was duly couriered and submitted in January 2023, confirming full procedural compliance. Crucially, Ms. Moretlo made it clear that she had no personal interest in the matter. Her involvement was purely administrative, assisting a complainant to navigate the official JSC process. Her testimony therefore reinforces the integrity and authenticity of the complaint initiation and handling. Mr. Abongile Chete, Judge's Secretary at the Mthatha High Court, provided an independent and balanced account that lends further credibility to the sequence of the event. He testified that he first became aware of the issue when he saw the screenshots of WhatsApp conversations between the complainant and the Judge President posted on Ms. Mbenge's WhatsApp status. Although the complainant's responses had been deleted, the posts confirmed that such communication had taken place. Shortly thereafter, ostensibly on work matters, but during the conversation appeared visibly anxious and admitted that the situation was affecting his health. He even sought Mr. Chetty's assistance to arrange a mediated meeting with Ms. Mbenenge, which she declined. Mr. Chetty described the Judge President as someone who often referred to himself as a father figure and who frequently communicated with secretaries after hours, mainly about work, but at times on personal issues, a pattern that sheds light on his interpersonal approach and boundaries with subordinates. He also assisted Ms. Mbenenge by advising her on how to proceed formally, but was careful to remain neutral and uninvolved beyond offering guidance. Importantly, Mr. Chetty harbored no personal conflict with either party and did not claim to have witnessed misconduct himself. His testimony was measured, credible, and reflective of a neutral intermediary attempting to assist both sides in a sensitive situation. Ms. Ntombokolo Brenda Jobela is the judge's secretary based at Gqeberha High Court and formerly served as a secretary to the Judge President, the respondent in this matter. Her testimony provides critical corroborative evidence regarding the complainant's early disclosures and the nature of the material she shared with trusted colleagues. Ms. Jobela testified that she received 3 images via WhatsApp from the complainant, Ms. Mbenenge. The first was a screenshot of a WhatsApp conversation between Ms. Mbenenge and her late colleague, which included an image of a man's private parts. The second was a motion picture or animated GIF depicting a sexual act. The third was a photograph of a man's leg taken in what was later identified as the JP's chambers. These images were transmitted to her without accompanying commentary, suggesting that the complainant sought to show rather than describe what she experienced. Importantly, Ms. Jobela clarified that the explicit image forming part of the record as Exhibit K8 was not the exact image sent to her. Rather, she received a screenshot of a screenshot containing superimposed text, specifically from a conversation between the complainant and the late colleague. This nuance demonstrates the complainant's consistent use of secondary screenshots as a means of documenting her exchanges while preserving the evidentiary chain of the original material. Ms. Jobela further testified that when the complainant first approached her, she stated that an older judge was harassing her, but not at that stage identified the Judge President by name. Concerned by the allegation, Ms. Jobela took it upon herself to confront one of the other senior judges, believing he might have been implicated. She even showed him the images, whereupon he firmly denied any involvement, stating that Ms. Mbenenge was like his child. Ms. Jobela's evidence is highly significant. It demonstrates that the complainant confided in a colleague well before the matter became public, that she shared corroborating material contemporaneously, and that her disclosure was not fabricated after the fact. It further illustrates her distress and uncertainty about how to proceed in this hierarchical environment where even trusted colleagues could also be potentially authority figures. Her testimony therefore corroborates both the existence of the images and the complainant's consistent narrative regarding unwanted sexualized conduct by a senior judicial officer. It shows that the complainant's actions were consistent with the victim seeking support and validation, not out of malice toward the respondent. Mr. Denham Krokwana, the Director of Court Operations in the Eastern Cape, testified to his direct involvement after the complainant informally raised concerns about the respondent's conduct. His evidence provides institutional confirmation that the matter was reported and taken seriously within the judiciary's administrative structures even before the formal complaint was filed. Mr. Krokwana testified that in late November 2022, the complainant approached him and reported that the Judge President had sent her inappropriate messages. She further related an incident that had occurred in the Judge President's chambers around 14 or 15 November 2022, during which he allegedly remarked to her, "You should see the effect you have on me." This statement, if accepted, reveals conduct that is both inappropriate and sexually suggestive, and entirely inconsistent with the decorum expected of a judicial leader. The complainant also indicated to Mr. Krokwana that she sought an apology from the Judge President and proposed that the matter be addressed through a mediated roundtable discussion involving female judges. This proposal underscores her initial preference for a restorative rather than adversarial approach, consistent with a complainant who is distressed yet respectful of institutional processes. Mr. Krokwana testified that this proposed roundtable was ultimately abandoned after the complainant publicly posted excerpts of her WhatsApp exchanges with the judge president on her WhatsApp status. Following this development, Mr. Krokwana advised her to pursue a formal complaint through appropriate channels, guidance which ultimately led to the complaint being lodged with the Judicial Service Commission. The importance of Mr. Krokwana's testimony lies in its corroboration of key factual elements. First, that the complainant made an early and consistent report of inappropriate conduct. Second, that her account of the incident in Chambers predates any public disclosure. And third, that the matter was handled with seriousness and procedural propriety at administrative level. Mr. Naidu testified on the CCTV system. Then I will go to Ms. Lisa Vetten. She was called as an expert witness to assist this tribunal in understanding the broader social and psychological context within which acts of sexual harassment typically occur, particularly where there exists a profound imbalance of power, such as between a judge president and a junior staff member. Ms. Vetten is a well-recognized authority in the field of gender-based violence, with over 25 years of experience in research, policy, and advocacy on violence against women in South Africa. Her work has consistently engaged with the dynamics of sexual harassment, power, and institutional responses, making her uniquely placed to assist this tribunal in interpreting the complainant's experience. Ms. Vetten explained that sexual harassment is not fundamentally about sexual desire. It is about power. It often occurs in environments where one individual wields significant authority over another. The conduct, though sexual in nature, functions as a mechanism of asserting dominance, control, and entitlement, thereby affecting the dignity, well-being, and working conditions of the complainant. She described how perpetrators frequently employ grooming techniques, beginning with flattery, seeming innocuous familiarity, or manipulative kindness, gradually escalating to more personal and inappropriate behavior. This progression creates confusion and discomfort for the victim, who often struggles to reconcile the conduct with the norms of a professional relationship. Drawing on extensive social science research, Ms. Vetten clarified that victims of sexual harassment rarely respond with immediate confrontation or formal complaints. Instead, they may attempt to deflect the advances politely, maintain cordial communication to avoid retaliation, or even continue seemingly friendly interactions out of fear of professional repercussions or reputational harm. Importantly, she emphasized that such behavior, including delayed reporting or polite replies, does not amount to consent, nor does it undermine the complainant's credibility. Rather, it is consistent with known patterns of coping and survival in contexts of unequal power. Ms. Vetten situated this case within the distinctive environment of the judiciary, where authority is both formal and deeply hierarchical. She testified that a judge president wields substantial institutional influence, enough to make any junior employee fearful of the consequences of resistance. Within such a structure, there are few safe or accessible channels for reporting misconduct, and the culture of deference to authority compounds the victim's sense of vulnerability and isolation. Turning to the WhatsApp exchanges between the complainant and the respondent, Ms. Vetten provided critical insight. She observed that the complainant's responses were often strategically polite or evasive, an effort she suggested to placate the respondent without confrontation. Several of the respondent's messages contained sexual innuendo or inappropriate familiarity, inconsistent with a professional relationship. According to Ms. Vetten, these communications reflect a grooming pattern, where rapport was first established and then progressively sexualized, a well-documented trajectory in cases of workplace sexual harassment. Her evidence further reinforces that apparent friendliness or humor in the complainant's replies cannot be taken at face value. When viewed through the lens of trauma-informed evidence-based research, such behavior aligns with established victim responses to harassment by a superior. Ms. Wetten's expert testimony provides a credible and scholarly framework through which the complainant's conduct and the tone of her communications must be understood. It underscores that compliance, politeness, or the absence of outright refusal does not signify consent. Rather, these are hallmarks of a victim navigating an unequal and intimidating power dynamic. It is therefore respectfully submitted that Ms. Wetten's evidence supports the conclusion that the complainant's account is not only plausible but consistent with established patterns observed in sexual harassment cases involving individuals of high authority. Her testimony affirms that what transpired here reflects the dynamics of power and control that underpins such misconduct, and that the complainant's responses were entirely typical of a victim attempting to preserve her safety, dignity, and livelihood within the profoundly unequal relationship. If we look at the evidence on behalf of the respondent, Ms. Nkayi testified regarding the alleged incident of 28 May 2021 that she did not witness the judge president hugging the court manager, Ms. Tambudala. However, during cross-examination, she conceded that such an incident could have occurred during a time when she was not in her office. Although she initially claimed to have been at her desk throughout the relevant period, she later admitted that she occasionally left her workstation, for example, to fetch files or use the bathroom. Concerning the alleged incident of 14 November 2022, Ms. Nkayi confirmed that the JP made comments about the complainant's attire, though she attempted to minimize their significance by describing them as part of the JP's daily talk. She noted that the judge president's chambers had two entrances, one of which was accessible through her office, thereby acknowledging that interactions could have occurred without her knowledge, even when she was present. She maintained that she left the office on that day, the 14th of November, after the complainant. However, the complainant testified that they met at the bed and breakfast. Although the laptop register reflects that the complainant signed out 11 minutes earlier than Ms. Nkayi, this does not preclude the possibility that Ms. Nkayi could have arrived at the B&B before her. There is no evidence suggesting that the complainant departed the court premises immediately after signing out the laptop, nor is there clarity on whether they traveled the same route. Ms. Nkayi's claim that her clothing was already packed in the vehicle is improbable, given her own assertion that she only learned she would not be returning to Mutata that afternoon at 16:15. It is respectfully submitted that it is implausible for the witness to recall the level of detail reflected in her testimony, particularly when she made no contemporaneous record of the events and only drafted a statement nearly 2 years later. Notably, her written statement contains no mention of the alleged incident of 28 May 2021. Yet in her oral evidence, she purported to remember specific details of that day, such as being unable to reach the court manager telephonically and deciding to walk to her office to call her. It is further respectfully submitted that Ms. Nkayi's evidence does not contradict or disprove the complainant's version. Overall, her testimony is marked by improbabilities and indications of bias. Her evidence fails to rebut the complainant's allegations and, in certain respects, inadvertently corroborates them, for instance, by confirming the JP's inappropriate commentary on the complainant's attire. It is therefore respectfully submitted that the tribunal should attach limited weight to her testimony. The next witness called on behalf of the respondent, Dr. Vincent Melo, respectfully did not take the matter further. It is respectfully submitted that Dr. Melo is not an expert qualified to interpret the use of emojis within a legal or forensic context. He is neither a forensic linguist nor a legal communication specialist. He confirmed under oath that membership of the Unicode Consortium, the body that standardizes emoji meanings, is open to anyone upon application and payment of a fee, without the need for any academic qualifications or expertise. As such, his affiliation does not confer any particular authority or expertise in the interpretation of emoji usage in legal proceedings. Crucially, Dr. Mele conceded that the emojis exchanged between the complainant and the respondent were not always used in accordance with their standard Unicode meanings, thereby undermining the reliability and relevance of any conclusions drawn from their appearance in the messages. In respect of the disputed messages, namely annexures H1 and H2, K8, N, and P, Dr. Mele further conceded that based on the evidence before him, he was unable to determine the original sender or recipient of these messages. This concession renders his testimony of limited probative value, particularly on the issues central to the respondent's denial of misconduct. When we turn to the evidence of the respondent, Judge President Mbenenge, we are confronted with a version that is riddled with improbabilities, evasions, and contradictions. His testimony, rather than rebutting the complainant's account, only reinforces it. The respondent sought to portray his interactions with the complainant as a harmless, even culturally grounded form of flirtation, suggesting that he was merely expressing interest in a manner consistent with Xhosa customs. Yet when pressed on a cross-examination, he could not articulate what this interest actually meant. At one moment it was a flirtation, at another it was a courting process. But in the very first WhatsApp conversation he had with the complainant, he asked her to send a naked picture, take off the top part. Honourable members, this is not a cultural overture. It is a sexual solicitation. It stands in direct contradiction to his claim that his conduct was innocent, respectful, or culturally appropriate. The respondent also told the tribunal that he would read the room, that he would somehow gauge from the complainant's responses whether his advances were welcome. But the record of the messages paints an entirely different picture. He was the one who repeatedly initiated sexualized conversations. He ignored the complainant's polite attempts to change the subject, and when she fell silent, he took that silence as consent. Even after weeks of no communication, he reignited the sexual dialogue, entirely unprompted. These are not the actions of a man reading the room. They are the actions of a man assumed consent where none existed. He further attempted to normalize his conduct by telling this tribunal that judges have relationships with secretaries and some even marry them. That statement is profoundly troubling. It shows a complete misunderstanding or disregard of the power imbalance inherent in the relationship between a judge president and a subordinate staff member. There is no evidence here of mutuality, no evidence of reciprocal affection. What we see is a senior judicial officer leveraging his position to persuade a vulnerable junior employee. On the issue of the 14th of November 2022, the respondent relied heavily on CCTV footage, which by his own admission was incomplete, lacked timestamps, and had significant gaps. His own movements are not visible. In other words, the footage cannot disprove the complainant's version. On the other hand, the complainant gave a clear, detailed, and consistent account of what occurred, an account that aligns with her immediate emotional reaction and the steps she took afterwards. The respondent's denial of having sent a sexually explicit image is equally implausible. When confronted with his reply, "Yours, please," sent immediately after an exchange about nude photographs, he could offer no reasonable explanation. That is not the response of someone unaware of what is being discussed. Throughout his testimony, the respondent leaned heavily on his reputation, his years of service, his leadership role, his record as a judicial officer. But professional stature does not place anyone above accountability. Indeed, it demands a higher standard of conduct. The evidence shows that his behavior was deliberate, sustained, and exploitative. He asked for messages to be deleted. He worried about his family finding out, and he sought to recast his messages as something other than what they plainly were. Those are not the actions of an innocent man. They are the actions of someone conscious of wrongdoing. In the end, the respondent's version is not only improbable, it is untenable. His explanations shifted as the evidence mounted against him. His cultural justifications were opportunistic, invoked only when convenient. His denials were not supported by any objective evidence, and his manner in the witness box, evasive, giving long-winded answers in an attempt to avoid addressing the actual questions posed to him, further undermined his credibility. For all these reasons, it is respectfully submitted that the tribunal should find the respondent's evidence unreliable, self-serving, and inconsistent with the objective facts before this tribunal. If we look at the incident, the alleged incident of the 14th of November 2022, an incident which lies at the very heart of this case and is central to understanding both the severity of the misconduct and the complainant's eventual decision to formally lodge a complaint. According to the complainant's evidence, the respondent in his chambers pointed towards his private parts and remarked, "Do you see the effect you have on me?" He then followed that up with a question, "Do you want to suck it?" This incident came after a period during which there had been a noticeable pause in sexually inappropriate messages from the respondent. That pause is important because it could reasonably have led the complainant to believe that the inappropriate conduct had ceased. Yet, this unexpected sudden escalation forms a context for the complainant's reaction, making her response all the more credible. In her own words, this interaction was the catalyst that finally prompted her to lodge a formal complaint of sexual harassment. It is further submitted that the complainant had any intention of that if the complainant had any intention of fabricating this allegation, she could have easily exaggerated the conduct, made it more physically invasive, or added sensational details. She did none of that. She reported exactly what occurred, specific, crude, and uncomfortable, yet contained. This aligns with patterns of misconduct in contexts where there is a stark imbalance of power, as is the case here, where the alleged perpetrator held authority over the complainant. There is no evidence before this tribunal that the complainant fabricated the incident. Her reaction, her evident distress, her communications with colleagues, and the eventual formal complaint all support the reasonable inference that she was responding to real traumatic events. The expert witness, Ms. Lisa Wetton, confirmed that delayed reporting, ongoing interactions, or even superficially cordial messages are entirely consistent with how victims behave in such circumstances. The fact that no third party witnessed the incident is neither surprising nor exculpatory. Misconduct of this nature often occurs in private. The complainant's account was clear, consistent, and critically fits within the broader pattern of the respondent's sexually charged WhatsApp communications and progressive boundary violations, as analyzed by Dr. Docrat and contextualized by Ms. Wetton. In these circumstances, it is submitted that the probability leans heavily in favor of the incident having occurred, as described by the complainant. Her account is credible, untainted by fabrication, and consistent with the respondent's documented behavior. If we now look at the initial complaint, the complainant filed a complaint without legal assistance, attaching screenshots of WhatsApp exchanges with the judge president. Not all of her responses were included, and the defense has attempted to use these omissions to question her credibility. Yet, as she explained, the complaint was never intended as a verbatim transcript, but as a good faith account of what she experienced as sexual harassment. All the messages before this tribunal were retrieved from her phone, unaltered and intact. By contrast, no relevant messages could be recovered from the respondent's device, as they had been deleted and overwritten. The inference is clear. The complainant preserved the evidence. The respondent did not. Her polite or diplomatic replies must be viewed in the context of a profound power imbalance, and employee attempting to manage an unsafe situation with caution, not consent. The incomplete initial complaint, when now read together with a full forensic record, only strengthens her credibility and confirms a consistent pattern of persistent, unwanted, and inappropriate conduct by the respondent. The respondent seeks refuge in technicality that the Code of Judicial Conduct does not expressly mention sexual harassment, and that workplace sexual harassment codes do not apply to judges as they are not employees. With respect, this argument misconceives both the nature and purpose of the code and the constitutional standard of judicial conduct. Section 14.4 of the JSC Act provides two bases for misconduct. A willful or grossly negligent breach of the code, or B, any other willful or grossly negligent conduct incompatible with or unbecoming the holding of judicial office. Even if the term sexual harassment does not appear in the code, the second ground expressly captures conduct that erodes the dignity, integrity, and propriety expected of a judicial officer. Sexual harassment strikes at the heart of those values. Articles 4 and 5 of the Code require judges to act honorably, uphold dignity, and to avoid using their office to advance private interests. Sexual harassment and abuse of power and trust is manifestly incompatible with judicial office. Its absence as a label in the Code cannot sanitize dishonorable conduct. The respondent's argument that there is no residual misconduct complaint outside sexual harassment misrepresents both the complaint and this tribunal's mandate. Section 14.4b explicitly empowers the tribunal to consider any willful or grossly negligent conduct unbecoming of judicial office, a provision to prevent exactly the type of narrow technical defense raised here. This case is not about morality or private life. It is about judicial integrity. The damage to the judiciary arises from the respondent's own conduct, not the complainant's disclosure. His conditional apology confirms as much, a belated recognition that his behavior was inappropriate. Even if the tribunal were to find that strict elements of sexual harassment are not proved, the respondent's conduct remains gross misconduct under Section 14.4b, willful, dishonorable behavior incompatible with judicial office. The respondent's reliance on the non-retrospectivity of the 2025 Judicial Sexual Harassment Policy is equally misplaced. While prospective in effect, it codifies long-standing principles that sexual advances by a judge toward a subordinate are inherently coercive and incompatible with judicial dignity. The policy is persuasive evidence of enduring ethical standards. The respondents further attempt to rely on cultural justification, ukumutsa, must also fail. Cultural interpretation cannot sanitize objectively inappropriate behavior. The concept was never put to the complainant and was introduced late as a post facto rationalization. A judge present cannot reasonably claim to have misinterpreted emojis as consent. Similarly, his appeal to freedom of association misconceives the nature of the judicial office. Judges accept limitations on personal freedom to preserve public confidence. This case is not about prohibiting relationships. It's about power, propriety, and respect. No amount of cultural or constitutional reframing can transform this pattern of conduct. Persistent, unwanted, sexualized communication with a subordinate into anything other than misconduct. I now turn to the legal and ethical framework within which the tribunal must assess the respondent's conduct. The actions of the judge president are not evaluated in isolation. They must be measured against binding legislation, workplace codes, and the Code of Judicial Conduct, a framework that clearly establishes what constitutes sexual harassment, workplace misconduct, and judicial impropriety. The Protection from Harassment Act defines sexual harassment as any unwelcome conduct of a sexual nature that causes harm. Critically, harm may be psychological or emotional, and a single incident can suffice. Similarly, Section 6.3 of the Employment Equity Act affirms that harassment can arise from a single event. The law recognizes that consent is invalid where it is obtained under coercion, intimidation, or an imbalance of power, a circumstance inherent in a judge-president's interactions with a junior administrative employee. The Code of Good Practice on Prevention and Elimination of Harassment in the Workplace provides further clarity. It confirms that sexual harassment includes non-verbal or suggestive conduct, including digital image messages, emojis, and gestures. It acknowledges that victims may respond passively, ambiguously, or politely when under pressure or fear of retaliation. The Code also imposes a clear duty on superiors to respect boundaries once discomfort is signaled. Even prior friendly or flirtatious exchanges do not validate ongoing unwelcome conduct. The Code of Judicial Conduct places judges at the highest ethical standard. Judges must act honorably at all times, respect the dignity of others, and avoid exploitative, sexist, or humiliating conduct. A willful or grossly negligent breach amounts to misconduct, particularly when it undermines public confidence in the judiciary. As a Labour Appeal Court noted in Gaga versus Anglo Platinum and others, the fact that a subordinate may initially appear flattered or ambivalent is no excuse, especially where discomfort has been signaled. That is precisely what occurred in this matter. Under Sections 14.4b and 14.4e of the Judicial Service Commission Act, a finding of willful or grossly negligent misconduct is required to sustain a complaint of gross judicial misconduct. It is respectfully submitted that this threshold is met here. What may superficially appear to be consensual behavior is in fact the product of fear, intimidation, or pressure arising from a severe power imbalance. Persistence in inappropriate conduct, despite signals of discomfort, is a hallmark of sexual harassment. The standard is clear on a balance of probabilities. The conduct must be assessed objectively. Here, the evidence shows that the respondent's behavior was unwelcome. It was repeated. It was harmful, and it created an unsafe working environment. The respondent's own admission that he may have been
Sorry to interrupt. You say the test must be what? Subjective? Go back.
It's the standard is clear on a balance of probabilities. This conduct must be assessed objectively. The respondent's own admission that he may have been mistaken and his apology reveal awareness of the impropriety of his conduct, a concession that is in itself telling. A reasonable member of the public would find it wholly unacceptable for the head of a high court division to persist in sexual advances toward a junior employee, particularly after rebuff and clear discomfort. It is also worth noting the sexual harassment policy of the South African judiciary, introduced in August 2025. While it is prospective in application, it underscores the judiciary's recognition of the risks inherent in power imbalance relationships. It establishes that even subtle signals, avoidance, ambiguity, or nonverbal cues suffice to indicate unwelcome conduct. Importantly, prior consent does not validate ongoing harassment. This policy aligns directly with the complainant's evidence and the expert testimony, highlighting that the respondent's conduct remained unwelcome regardless of any prior interactions. In conclusion, this tribunal is tasked with deciding whether the judge-president's conduct constitutes gross misconduct on a balance of probabilities. The evidence shows persistent, unsolicited, sexualized and inappropriate communication corroborated by expert analysis and by the respondent's own admissions. The complainant testified consistently, showing courage in reporting a senior figure despite fear of retaliation. Public trust in the judiciary is imperiled when its leaders engage in conduct that would be unacceptable in any professional setting. Viewed cumulatively, the probabilities favor the complainant's account. Her testimony was corroborated, consistent with known victim behavior, and given without embellishment. The respondent's conduct was inappropriate, non-consensual, and constitutes sexual harassment under both the Code of Judicial Conduct and broader legal standards. It is therefore respectfully submitted that this tribunal should find that the respondent is guilty of gross misconduct in the form of sexual harassment. Thank you.
It does not seem as if, it seems as if you've got other heads there as well, from the ones that we have.
It's just a narrative that I drafted for myself. It's not heads of argument, but if you want me, I can draft
I
it in
think it
heads
will
of...
be helpful if you can just put it in the way of heads as well, because your heads are very short in here, and there you gave us a much larger picture of what the matter is all about.
I will do so.
So the test is objective.
Indeed, Chair.
If you read the messages, the WhatsApp messages, if upon objective reading, they don't convey a message of unwanted messages, what then?
Yes, it is indeed so that in the majority of the WhatsApp messages, she did not rebuff him in the words itself. That is the reason why we had to call Ms. Lisa Vetten to explain that. But if we look at
Sorry, don't go there now, because you can't call somebody to come and interpret the message of somebody else. Abrix Kakane asked her, are you a trained psychologist to come and read people's minds? She said, no. So don't go there. Don't go there. Let's go to my question.
But if we look at...
Can I just pose that question? If the test is a reasonable man, if you look at some of the messages that she herself wrote, to a reasonable man, they don't convey unwanted response, what then? Because the test is objective. It's not Dr. Vettel's subjective interpretation.
No, it is true. But if we look at her messages, she does not answer him clearly. She tries to avoid the conversation, and she came and explained that. She did not know how to answer him. But if we look at the 20th of June...
Thank you to interrupt, because you're not answering my question. I don't want us to argue. I said to you, what if objectively reading the messages that don't convey unwanted participation? What then?
Then we must look at this 20th of June, where she specifically said no, and she even quoted a Bible verse. So there is instances in her messages where she came out to say no.
Where there isn't?
Then the court must decide what is in front of, not the court, the tribunal must decide what is in front.
And by the way, you speak of the 20, you talk about in East London.
That conversation, yes.
Yes, but the respondent agrees. In that context, there was a rejection because the respondent asked the question, if we meet there at your place, and the danger being that we may melt, shall we end up with being intimate? She said no. And the respondent accepts that there was a rejection with regard to the suggestion of being intimate, but not to flirtation. Let's distinguish that. But anyway, I just wanted to ask you that because, you see, the real question here is whether, upon reading the messages, which we're going to read, the real question will be whether the messages objectively, reading them objectively, what do they convey? That's what's going to happen, isn't it?
That is correct.
And if you find that they were unwanted, well, they were unwanted. If you find that they were wanted, or some of them were a mixture, we shall so find. But we are going to read the messages ourselves.
But
I
that
just
is
want
why
to-
it is important to note that even a single incident constitutes sexual harassment. So where she said no and he continued after that, that constitutes
Yes.
sexual harassment.
You said she never initiated.
Initiated sexualized messages.
Yes, thanks. You
Yes.
said so.
Yes.
Is that correct?
She never initiated it.
All right, okay. If we find that she did initiate,
Then I am mistaken, but according to my reading of the messages, I could not find that she initiated the sexual conversations. She might have answered to it, but she never initiated it.
you referred extensively to the incident of the 14th.
Yes.
Is it the 14th or the 15th?
That is still not clear.
Is
According
that
to
not part of the problem? That up to now it's not clear?
that is a problem, Chair.
And there's something that I want to ask you about that, because you talked about it quite a lot. I noticed that there is an argument by respondents' attorneys that with regard to the 14th, when the complainant said she left the court in the afternoon at a certain time, they asked you, sorry, you remember the complainant, the respondent asked for and produced, after this allegation came up, a recording of the movements of his vehicles on the 15th, which showed that he left the court around the 15th to some other place. I noticed that the respondents' lawyers say that because the complainant says that she left at a certain time on the 14th, and they say no, she left earlier than the JP secretary. I noticed that they asked you to produce a record showing the movements of a vehicle, apparently it's a government vehicle. They say that they asked you to produce a record of the movements of a vehicle on the 14th. Do you recall that?
I recall that.
Why was that not done?
At that stage, it was not known that they are talking about the fact that the complainant left, the leaving of the premises from the complainant and the judge's secretary, that there was a discrepancy. The laptop register was only provided later. It was never in dispute that the complainant was there. It was never in dispute that the judge president was there.
But there's a dispute as to when she left. The
But that-
dispute is, let's not fudge issues.
Yes.
The dispute is, the respondent says the complainant left before the JP secretary. The complainant had said the judge's secretary had left earlier. But the respondent says, no, the person who left earlier is the complainant and not the judge's secretary. And then they produced a record, security register, which shows that the complainant left earlier and the JP secretary later. That is the dispute. And then they said, to confirm the fact that the complainant left earlier, please produce the records of the movement of her vehicle.
No, that was not what was requested. At the stage when it was requested for the tracking record, it was not known that the judge's secretary left after the complainant. That was not known to me at that stage.
Anyway, if I'm wrong about that, they will speak for themselves, because that's what I thought. And okay, I think those are the clarifications I sought.
Thank you, Chair.
Advocate Skippers, just one question for you, please. In the event you are to find that the conversations or the exchange of email of WhatsApp messages between the complainant and the JP were consensual, would that still sustain the charge of sexual harassment then?
No, because then it's not unwelcome. If it's consensual, then the unwelcome part falls away.
Then what about then the element of gross misconduct then?
If there's no sexual harassment, there cannot be gross misconduct.
Okay, thank you. Thank you.
Sorry, there's something you referred to lack of credibility on the part of the respondent in your submission, and you are entitled to do that. Are there no aspects in the complainant's evidence which raise issues of credibility? If there are, you haven't mentioned them.
I think there is definitely aspects of credibility issues on the complainant's testimony. She could not give answers, especially when she was cross-examined on the two different statements that were exactly the same. So there are definitely some credibility issues in the complainant's evidence as well, but we must also look at what the objective facts, the WhatsApp messages that we have in front of us. That is what we have to deal with as well.
Does it not worry you that the complainant, and this came through questions by Advocate Butland, does it not worry you that the complainant sought to cast Ms. Moretwe as lying when she said, Ms. Moretwe said, I left at 9 o'clock because it was getting late. The complainant said no. And we know why she said that, because she was insisting about the fact that she didn't have a copy of the other statement. The complainant says no. Ms. Moretwe didn't leave at 9 o'clock. She left at 12 o'clock, midnight. She left after 12 o'clock midnight. It's a concerning aspect because when Ms. Moretwe says she left at 9 o'clock because it was getting late, all of us knowing how dangerous it is in this country for a young woman, and she says, and then somebody says she left after 12 o'clock, which, well, I don't know whether she would have felt safe to leave at 12 o'clock, but it's improbable. Does it not bother you that, with reference to those two statements, does it not bother you that complainant went so far as to cast Ms. Moretwe as lying when she says she left at 9, and conveniently, seemingly pushes her stay to 12 o'clock to accommodate the previous lie? Does it not bother you?
It is not good for the complainant's case, yes.
Yes. Advocate Butland.
Thank you, Chairperson. Chairperson, the questions that you've just asked my colleague, the evidence leader, I will respond to as well, since they are clearly questions that concern the panel, but I'll do so towards the address, with your permission. Chairperson, members of the tribunal, let me start to file written submissions and also to address you today. These proceedings have run on and off since January this year, and they have not been easy for anyone involved. We have said repeatedly, and we've been criticized for doing so, that these proceedings are unprecedented. But they are indisputably so. And it's not because sexual harassment is not common. We know that it is incredibly common. But it's because this is the first time that a sitting judge has had a complaint referred to a judicial conduct tribunal on the basis that the complaint establishes a prima facie case which, if substantiated, is likely to result in a finding of gross misconduct. How this tribunal deals with this complaint will set the standard to which we hold our judiciary, will send a message to the public at large about what we consider to be appropriate behavior from a judge and what is not appropriate. This case raises complex issues, but the question that sits before this tribunal is not complex. It is contained in the terms of reference, which provide, and I quote, "The allegation is whether or not, as a result of the conduct referred to in Ms. Mengo's complaint, Judge President Mbenenge is guilty of gross misconduct in terms of Section 177 of the Constitution." And I'll come in the course of my submissions to an analysis of Section 177 and of the meaning of gross misconduct. But for purposes of this introduction, let me say this: we will submit that the conduct which Judge President Mbenenge himself admits to, let alone what he disputes, that it in itself amounts to sexual harassment, and that it is conduct which we will contend constitutes gross misconduct as envisaged in Section 177(1)(a) of the Constitution and Section 14 of the Judicial Service Commission Act. We know that sexual harassment is prevalent in our society. We know that. We've quoted statistics in our heads of argument. Our heads of argument refer to a report by Judges Matter, which reference the fact that sexual harassment in the South African legal profession is more prevalent than the global average, and that 43% of women in the legal profession have reported experiencing sexual harassment, and that 25% considered leaving or have left the profession. And that you'll find at page 41 of our heads. So this complaint is important. It is only about Ms. Mengo and Judge President Mbenenge, but it also is not. How this tribunal assesses the evidence and the conduct of the Judge President will likely determine whether other women with legitimate claims come forward with their cases. Now, clearly, this tribunal has to make its decision based on this case.
Sorry, I don't understand that point.
Well, if
You can't say how we do it will determine. Each case is adjudicated according to its own facts. We are going to determine this case, as I said at the beginning, according to the law and according to the facts before us. As what the outcome thereof is, we don't know.
Chairperson, as I was saying, it's clear that this tribunal will make its decision based on this case and these facts. But the import of this ruling will have an impact on how issues of sexual harassment are dealt with in the future. Now, it's not to say that that must sway your decision because you must apply the facts. But we cannot pretend that when we make findings about how women are required to behave and how that behavior translates into whether or not there is perceived consent, for example, that will not have an effect on other women and whether they choose to come forward with complaints. That is the extent of my submission. This case is important, and we cannot pretend that it's just about these two people. It is not. Now, I have noted that the tribunal has, thank you very much, read our submissions very carefully and considered them, and I will certainly try and keep my submissions short and focused on key issues and themes. I've also noted, listening now to the evidence leader's submissions, that there are things that she has dealt with that I will try not to repeat. But I would ask the tribunal to bear with me because I've only just heard those submissions. I intend in my submissions to deal with the following issues. First, I'll provide a very brief overview of the complaint and the respondent's version. Then I will deal with the standards that we expect of judicial officers and how they apply to the respondent. Third, I'll deal with the correct definition of sexual harassment and its implication for the evaluation of evidence in these proceedings. And then fourth, I will respond to some of the arguments raised in support of the respondent through the course of these proceedings, but pertinently in the heads of argument of the respondent. So to start with a brief summary of the case to contextualize my submissions. The versions of the complainant and of the respondent are summarized in our heads from pages 29 to 47. I'm not going to repeat them. What's relevant is that we have evidence from the complainant who testified over the course of 10 days. 4 of those days were under cross-examination. We will submit that she was consistent, that she was open, and that she was honest with this panel. There may have been things where she did not have an answer, but she did not shy away from that. There may have been answers that we don't like, but she didn't shy away from that. She brought evidence to this panel that did not all portray her in a good light, but she brought all evidence that she had to this panel. So we ask that her evidence is considered in that context, and I'll respond in due course to the chairperson's questions around her credibility. Now, the complainant testified that she did not want to engage in either a romantic relationship or in sexual conversations with the judge president, but that she felt compelled to respond to his messages because of their relative positions. She testified that the conduct was unwanted, that it was persistent, that it was of a sexual nature. She also testified that she said no on many occasions, and we counted these through the transcript. There are approximately 13 occasions on which the complainant said no, either specifically using the word no or using words such as "it is impossible" when asked whether she would melt by the judge president, when she told him you must control yourself, and various other instances quoting the Bible verses where the first word hai means no. So in different ways, this complainant, if you look at the WhatsApp, said no many times during the course of this, 13 that we can count. She testified that she did not see the respondent as a romantic partner, but she saw him as an elder, a leader in the court, and at times a father figure. She testified that she was shocked by his advances and she was confused about what to do. In response, the respondent's defense can be summarized as follows. A respondent admits to having initiated WhatsApp conversations with the complainant. He admits that they were clearly of a sexual nature. He admits to having persisted in requesting sexual photos of herself, or rather naked photos of herself. He admits a request for them to be intimate. However, he says he was merely engaging in a consensual relationship, that this was a cultural practice, and that his attention advances were welcomed by the complainant. And overall, he says that it was objectively reasonable for him to assume consent in light of their conversations. So in short, he says these conversations were welcome, and there was no way in which he could reasonably have been expected to know that they were not. Well, we will argue that it's not just factually incorrect, but that any reasonable person in the position of the judge president would have realized that his conduct was not just inappropriate, but it was unwanted and was in conflict with his obligations as a judicial officer. On the judge president's own version, he admitted to having badgered her and persisted in his attempts to get her to send him photographs, to engage in sexual conversations, and to be intimate with him. In fact, in support of this, he testified that this was part of a cultural practice, which permitted him to refuse to accept a no from her, from a woman that he was courting, because she couldn't have meant no in this ritual. Now, that was never put to Ms. Mengo, and I'll come back to that. Now, the logical conclusion of this argument, if it's held to be valid, is that it is permissible to persist and to badger a woman to engage in sexual banter with you, to send you photographs of herself, to be intimate with you, until she eventually gives in and engages. That's the logical conclusion of that argument, because it's clear to her that she has to engage at some point because you're not going to accept a no. So even if she engages because she wants you to leave her alone, that will be taken as consent on your part. That's the logical conclusion of that argument, which we say must not be held to be valid. In fact, we say that is the very definition of sexual harassment. It's unwanted sexual attention of a sexual conduct that is often persistent. It doesn't have to be persistent, but often it is. So while we go through the evidence and while I make these submissions, I'll ask this tribunal to ask itself whether the conduct that the judge president himself admits to having done, just those, what he admits to having done, whether those conversations that he admits to having with a junior secretary in his division in circumstances where he's a leader of that judiciary is conduct that this tribunal considers to be in line with the Judicial Code of Conduct and in line with the standard that we expect of our judiciary. Because what is at issue here is his conduct. It's not her conduct. It does not matter whether you like the complainant. It does not matter whether you think that the way she chose to respond to his persistent badgering for sexual attention was how a perfect victim should respond. What matters in these proceedings is whether the judge president's conduct meets the requisite standards of a judge. And we submit that it does not, that his conduct evinces a clear indication of sexual harassment, that it amounts to gross misconduct in terms of Section 177 of the Constitution. More than that, we submit that his conduct was so blatant and abusive that it has eroded confidence in the judiciary and that it has brought the institution into disrepute in the eyes of ordinary South Africans who watch these proceedings. The conduct to which the judge president admits, if it happened in any other workplace in South Africa, would, I submit, constitute gross misconduct and would be a dismissible offense. And in the judiciary, where we are told to hold our judges to a higher standard, there can and there should be, we submit, no conclusion short of this. So that brings me to the question that this tribunal has to engage with, which is, what is misconduct? Now, the starting point of what this tribunal has to consider is gross misconduct in 177 of the Constitution. But what do we do where the Constitution doesn't specify what types of instances, what types of conduct will amount to gross misconduct? Well, in Hlophe versus the Judicial Service Commission and others, that's cited in our heads of argument, but the reference is 2022 3 All SA 87, it's a Gauteng division. The court looked at what is gross misconduct and how it is to be determined. And they said the starting point is the Constitution. They said Section 177 of the Constitution provides that a judge may be removed from office only if the JSC finds that the judge suffers from an incapacity, is grossly incompetent, or is guilty of gross misconduct. And the court went through analysis and how that it was not helpful to consider the concept of gross misconduct in the context of, for example, labor law, which was one of the arguments raised. But that instead, and I quote, what constitutes gross misconduct must be understood in the context of the whole of Section 177 1A. When the other two expressly mentioned grounds for removal are taken into account, it seems incontrovertible that what is contemplated is conduct that renders the judge unfit for a judicial role. And that you'll find at paragraph 116 of the Hlophe judgment. So it's conduct that renders the judge unfit for a judicial role. The court also held, and I quote, that the tool of a threshold of misconduct, which intrinsically requires a hierarchy of sin, is mechanical. As such, it is dysfunctional to the purpose of Section 177 1A. What is required, the court said, is a fact-specific inquiry in the round into all the relevant events upon which foundation of finding of fact can be made, which is then subjected to a qualitative assessment as to whether a person who behaved in the proven manner is fit for purpose in a judicial role. So we will submit that if one is to apply, as the court says we must, a qualitative assessment of the evidence before this tribunal, we would submit that the judge president is guilty of sexual harassment and that his conduct rendered him unfit for a judicial role. And that then constitutes gross misconduct as contemplated in 177 of the Constitution. Now, one cannot simply consider this without looking at what are the appropriate standards for judicial conduct, which also find their way into a determination of whether or not there's been gross misconduct. The respondent disagrees with us on this. They argue that the Judicial Code of Conduct finds no application in these proceedings. And somewhat curiously, they base this on the fact that the judge president, they say, has not been charged with dishonorable conduct. And if he's not charged with dishonorable conduct, then one doesn't have to have regard to the code. Now, we respectfully submit that that's incorrect as a matter of law, that it misses the point and ignores the provisions of the Judicial Services Act. First of all, Section 12 sub 5 of the Judicial Services Act provides that the code shall serve as a prevailing standard of judicial conduct, which judges must adhere to. And then the code itself, in item 10 of its preamble, specifically states, Section 12.5, read with 14.4b of the Act, that's the Judicial Services Act, Commission Act, specifically provides that the Code of Judicial Conduct shall serve as a prevailing standard of judicial conduct, which judges must adhere to, and that any willful or grossly negligent breach of the code may amount to misconduct, which will lead to disciplinary action. So what we see here is a link, a very clear link, between the Code of Judicial Conduct and the Judicial Services Act. Both those things guide this tribunal, and I would submit that to make a finding of misconduct or lack of misconduct without looking at the Judicial Code of Conduct, it would be wrong to do so. Now, there are only, if one looks at the Act, there are only a limited number of grounds on which a complaint can be made against a judge. Those are in Section 14.4 of the Act. The complainant, in bringing her complaint, you heard from the evidence leader, she was not legally advised at that time. She did not identify any particular section of the Judicial Services Commission Act as the basis for her complaint. But Section 14.4 of the JSC Act specifies the grounds on which a complaint can be made, and we submit 3 of them may be relevant to this tribunal. Those are in Sections 14A, B, and E. 14A lists one of the first ground on which you can lay a complaint against a judge as being incapacity, giving rise to a judge's inability to perform the functions of judicial office in accordance with prevailing standards, or gross incompetence, or gross misconduct, as envisaged in Section 177(1)A of the Constitution. So gross misconduct is referred to in 14A. 14B deals with any willful or grossly negligent breach of the Code of Judicial Conduct. And 14E refers to any other willful or grossly negligent conduct other than conduct contemplated in paragraphs A to D above, that is incompatible with or unbecoming the holder of judicial office, including any conduct that is prejudicial to the independence, impartiality, dignity, accessibility, efficiency, or effectiveness of the courts.
Sorry, those then will be a misconduct other than gross misconduct.
Yes, it's an unusual framing in the Act. Gross misconduct is referred to in paragraph A. So but paragraph A actually includes both incapacity, gross incompetence, and misconduct, which reflects the Constitution, basically. Those are the 3 main grounds on which you can impeach a judge. And then
My suspicion is that at some point we may have to focus on that except blah, blah, blah. We may have to, the category of conduct as opposed to category of gross misconduct. We may have to look at that more closely.
Yes. Chair, you raise an important point because actually when one reads the respondent submissions, I may be misunderstanding the argument, but there is a fair amount of emphasis placed on what was reasonable, what a reasonable person in the position of the judge could have been expected to do, and that then triggers questions around gross negligence rather than purely misconduct. I would suggest, I would submit that that when one looks at all of that, these are grounds on which you can lay a complaint. Ultimately, the finding will be one of gross misconduct because that links with Section 177 of the Constitution. But we can engage with that further if the panel would like to. Now, when one looks at the code, I don't want to, the evidence leader went into some measure of detail on some of the provisions of the code, so I'm trying not to repeat that. But it's important to note that the aim of the code is to, quote, assist every judge in dealing with ethical and professional issues and to inform the public about the judicial ethos of the Republic. So that is the purpose of the code. And one would imagine that when a judge is in a position that he or she thinks that they need to evaluate their conduct or to question how to behave in a particular situation, that this code of conduct would guide and assist that judge. In fact, it says so. It's to assist every judge in dealing with ethical and professional issues. So it's important to look at this code in a case such as this. I've already mentioned that the Code of Conduct serves as a prevailing standard for judicial conduct, which judges must adhere to. It also incorporates the Bangalore Principles, which are the internationally acceptable principles that South Africa has signed on to. And so there's an international aspect to the standards that we apply to judges. And one sees this where we referred to a case from the Ninth Circuit of the US Court of Appeals, which didn't obviously refer to our code, but referred to their code, and that some of the language was very, very similar. This is because these are international standards that that judges are held to in the countries that have signed on to the Bangalore Principles. Now, Article 5 of the code was referred to by the evidence leader. Article 5 deals with the obligation to act honorably. Importantly, it provides that a judge must always, not only in the discharge of his official duties, so he must always act honorably and in a manner befitting judicial officers. There's an explanatory note to each article, as the panel will be aware, and the explanatory note to Article 5 explains that a judge behaves in his or her professional and private life in a manner that enhances public trust in or respect for the judiciary and the judicial system. So, and then it says a judge avoids impropriety and the appearance of impropriety in all the judge's activities. And then note 5 sub 4 says judicial conduct is to be assessed objectively through the eyes of a reasonable person. So that is in line with the question asked of the evidence leader. The conduct must be evaluated objectively, must be assessed objectively. In our heads, we refer to 3 cases in support of this. We refer to the Mutata case, the Hlophe case, and the US case that I've just referred to, the Kindred case. I'm not going to go into detail into those cases. They are dealt with extensively in our heads of argument. But suffice it to say this, that each of those cases, particularly Mutata, emphasized the importance of public perception, and that links with the idea of what a reasonable person how a reasonable person would assess the conduct in question. The respondents in their heads of argument suggest that the Mutata case is not relevant because in that case, Judge Mutata had already been convicted of a crime. But in fact, that misses the purpose for which we are citing this judgment. The respondents suggest that we are premature in relying on that because there's no conviction here. But that's not what we rely on it for. We rely on it because in Motata, the SCA quoted the Supreme Court of Canada in relation to the standard expected of judges in general. And I quote, public confidence in and respect for the judiciary are essential to an effective judicial system and ultimately to democracy and founded on the rule of law. And the SCA in that case specifically explained that there is a link between the perception that a reasonable person holds of the judiciary and the effective administration of justice. And we quoted in our...
Sorry, but that picture is founded on the fact that Motata was convicted.
No, it's not. If one reads the judgment, it is about his conduct as a whole. So it's not just about the conviction. It looks at the conduct of Judge Motata in how he responded, the racist comments that he made when he was on the scene, and his behavior as a whole. And so this, what the Supreme Court of Appeal says about the perceptions of the Republic is about how we view judges' conduct. It's not about how we view judges' conduct once they've been found guilty of something. It's in general. And in fact, they say at paragraph 81 of the judgment that the Judicial Service Commission has been charged by the Constitution and the Judicial Services Commission Act to inter alia protect the integrity of the judicial system. In discharging that function, it had to be sensitive to the expectations of a reasonably well-informed and dispassionate public, that holders of judicial office would at all times remain worthy of trust, confidence, and respect, at all times. So, in our heads, you'll see that the SCA quoted Lord Phillips in a case from the Supreme Court of Canada, again, talking about the standards required of judges, the public perception of that, and the fact that the public requires, whether we like it or not, virtually irreproachable conduct from anyone performing a judicial function. And that the standards require is the appearance of that conduct, as well as the conduct itself. Chair, I see that it's 1 o'clock. I'm not sure if you'd like me to continue. I still have a fair amount to get through.
I think continue. Where we'll have to stop maybe at 1:30.
Sure.
I think they will have to, the Secretariat will have to confirm with us whether we can go for lunch at 1:30. Yes, you can proceed in the meantime.
Okay. Then, in line with the subjective standard that the SCA in Motata referred to, our heads also deal with Hlophe judgment, which also talks about the importance for a judge to remain visibly and manifestly imbued with integrity and act with good judgment. And of course, as I referred to the US case. We submit that in Judge President Mbenenge's case, there is no circumstance under which it was appropriate conduct for him as a leader in the judiciary to engage in the manner that he did with Ms. Mengo. Now, I say in the manner that he did because there was a suggestion that there's nothing wrong with a judge having a relationship with the secretary per se. That, in fact, we were told that some judges have married secretaries. That misunderstands our argument. It's not to say that we don't think that there are instances in which there can be consensual, permissible relationships. There is no bar on relationships within the court system. What we're saying is that the manner in which this took place was inappropriate. Now, if the judge president had genuinely wanted to engage in an open relationship with Ms. Mengo that everyone in the court was aware of, there was no secret about it, there's nothing wrong with that. There's nothing wrong with dating a secretary. But this, and what one sees from the WhatsApps is, and even from the respondent's testimony, is that's not what it was. This was about wanting to engage with her on sexual content only. This was wanting to be intimate with her without having a formal relationship. And Ms. Mengo said in her evidence that that is why she said to him, come out clear. Come out clear. Because her understanding of someone who wanted to have a relationship with you was that they would, in her language, propose. Now, that's not a proposal of marriage, but it is to propose a formal relationship. I would like to date you, for example. But she said in her testimony, and we can find the reference if necessary, that that was not what she received from the judge president. What she received instead from day one was a request for pictures of herself, where she removed the top part of her clothing, kulula mutla. So this whole case may have been very different if a different relationship, if there was an intention to have a different kind of a relationship, and if that was conveyed clearly to Ms. Mengo, and if she was given a proper opportunity to say no. She said no, that was respected. That is not what this case is about at all. And what we've seen from the Code of Conduct is that there is a standard required of judges, at a minimum, I would suggest, to make sure that when you're engaging with someone, you do so in line with that Code of Conduct. In your public life, in your private life, that's what the code says. You are always a judge. You are never not a judge, and you are never not required to comply with those standards, as high as they are. So with those standards in mind, I'd like to turn to the definition of sexual harassment. It's important to start by understanding what is sexual harassment and how this tribunal must seek to identify whether the conduct before you constitutes sexual harassment. And some of the questions from the panel, some of the evidence from the tribunal have suggested that a rather simplistic understanding of what is or what isn't sexual harassment. And the evidence of the experts was an attempt to show that it is not that simplistic. But I'll come back to that. Let's start with the definition. The respondents asked this tribunal to use the definition of sexual harassment in the Equality Act. And they say in their heads of argument that you'll find the definition of sexual harassment in section 1.1 of the Act. But you won't find a definition of sexual harassment in 1.1 of the Act. What you'll find is a definition of harassment on various bases. One of them is on sex and gender. That is different, we submit, to a definition of sexual harassment. And that's why we don't use the Equality Act, we use the Employment Equity Act. What's one of the reasons? The Employment Equity Act itself addresses sexual harassment directly, squarely. It provides detailed understanding of what sexual harassment is, what processes must be used to determine sexual harassment, and provides a court, or in this case, if this tribunal considers it, this tribunal, with guidelines about how to deal with sexual harassment. So the Equality Act, we would submit, is not the right framework to use for understanding sexual harassment. The correct framework is to be found in the codes of good practice on the prevention and elimination of harassment in the workplace. Those are issued under the Employment Equity Act. But the most important indication that this is correct is that the Equality Act itself, in section 5.2, states that this act does not apply to a person to whom and to the extent to which the Employment Equity Act applies. So if the Employment Equity Act applies, as it does to Ms. Mengo because she's an employee, then you don't look at the Equality Act. You look at the Employment Equity Act. And if one was to have taken this to the Equality Court, for example, that would have been an argument raised about the correct jurisdiction of that, whether that court had jurisdiction. So the Employment Equity Act self-evidently applies to her. It is because she's an employee and that this conduct took place in the context of her workplace and in the context of her work as a judge's secretary. The WhatsApps make it clear that on various occasions, the JP would message her only about work, or that on other occasions he would always start with asking her work-related questions and then move on to the more sexual content. So, and we saw that when he asked about protests near the court, when he asked her what her judge was doing, all of those sorts of things. So this conduct took place in a workplace, and it is irrelevant for purposes of the law whether the judge president was Ms. Mengo's employer or not. Much was made of the fact that he was not her employer, but he doesn't have to be her employer for purposes of the Employment Equity Act. It is not necessary that he himself is an employee even under the Act. The Act specifically says that it applies to employees, but it also applies to situations in which third parties, such as, and they list a series of potential third parties, outside contractors, for example, are accused of sexual harassment of an employee. So the Act squarely applies, and it is irrelevant whether or not Judge President Mbenenge is an employer of Ms. Mengo. His position is relevant to balance of power and to other issues, but not to whether or not the Employment Equity Act applies. The fact that the court system in general is considered a workplace is also made clear from the most recent sexual harassment policy that was issued by the Chief Justice in August 2025. I'm not suggesting that it applies to this case, but it is helpful for this tribunal to look at what the Chief Justice and the Office of the Chief Justice considers to be sexual harassment. And specifically in that policy, it states that the South African judiciary acknowledges that each of its members are in positions of considerable power, authority, and influence in relation to staff in the judicial working environment, members of the legal profession, and the general public. Sexual harassment is an abuse of power, and for this reason, it is a responsibility of every member of the South African judiciary to remain vigilant of how their conduct may be received or perceived by those with whom they do not share the same power, authority, and influence. And the respondents say the policy is not relevant. It is relevant. It's relevant to this extent. It codifies the existing law on sexual harassment. It sets out the standards required of judges' conduct and codifies them. Most importantly, it provides this tribunal with an indication of the manner in which sexual harassment is to be understood going forward and treated in the context of the judiciary. So it would, we submit, be an extraordinary thing for this tribunal to find that the court environment is not a workplace for purposes of this complaint, where the 2025 sexual harassment policy explicitly makes it clear that it is. But as I said, in any event, the 2005 code on prevention of sexual harassment makes it clear that it applies to employees, but also to people that are not employees in the engagement with an employee, and that is dealt with in our heads at paragraph 63. Now, in terms of finding a definition of sexual harassment, there are various codes that are set out in our heads of argument under the Employment Equity Act. In Campbell Scientific, Judge Satch, trying to remember which judge it was, but in the case, the relevant case is Campbell Scientific. I think it was Judge Savage, who indicated that the codes don't supersede each other. So one must effectively read all of those codes together to understand sexual harassment. So we detailed the various codes in our heads of argument from page 58, but in short, sexual harassment is defined as unwanted conduct of a sexual nature. The unwanted nature of sexual harassment distinguishes it from behavior that is welcome and mutual. Importantly, the code goes on to say that sexual attention becomes sexual harassment if the behavior is persisted in, so if there's persistence, although a single incident of harassment can constitute sexual harassment. And then, so that's one factor, and or the recipient has made it clear that the behavior is considered offensive, and or the perpetrator should have known that the behavior is regarded as unacceptable. So any one of those three factors would satisfy the definition of sexual harassment. I'll just refer the tribunal to the fact that the 2005 code, which is also set out in our heads, sets out a test for sexual harassment and requires a court taking this into account to consider a series of factors, whether the harassment is on the prohibited grounds of sex or gender, sexual orientation, whether the sexual conduct was unwelcome, the nature and extent of the sexual conduct, and the impact of the sexual conduct on the employee. Those are all relevant factors. The code also sets out different ways in which an employee may indicate that the sexual conduct is unwanted, and that includes verbal conduct, but also non-verbal conduct, such as walking away or not responding to the perpetrator. And again, that code applies broadly to workplaces and the working environment. Okay. Now, if I can then turn to this issue of a power imbalance. A power imbalance is, or an imbalance of power, is a common constituent of sexual harassment. Ms. Vetten testified to that. It's also recognized in the 2005 policy on sexual harassment, policy for the judiciary. Now, the respondent was at pains to contend that he had no power over the complainant, but the complainant contradicted this specifically. In fact, she testified to this power imbalance on several occasions. For example, on the 13th of January 2025, page 25 of the transcript of that date, she said, about why she responded to the judge's messages, she said, "He's a powerful person. We are in charge of the entire province. It was difficult to say no to him, although I said no, no, no on numerous occasions, but he did not listen to that or hear my no. More than anything, I was scared of how he was going to treat me at work because I do not know what he was going to do to me, and there was no one who was going to believe me if I were to convey my story." So her perception of the respondent's power is also evident in her trying to bring her concerns with the court manager, for example, to his attention. The judge president had power in that division, and she recognized that he had that power, and that is why it was so difficult for her to deal with how, perhaps in a way that may have made all of this much simpler, it was very difficult for her simply to ignore his messages completely, for example, not respond to them, because it was the judge president who was messaging her. Now, the Constitutional Court in Mbenenge, which is also quoted in our heads, looked very closely at the long history, an accepted history of this notion of a power imbalance and how it operates in the context of sexual harassment. And in the Constitutional Court case of Mbenenge, it was about a doctor sexually harassing an intern. And in that case, the doctor was not the intern's employer. The Department of Health was the intern's employer. But the Constitutional Court still found that that hierarchical level within the workplace amounted to an imbalance of power. And that imbalance of power was a relevant factor in determining sexual harassment. And this was also confirmed by Dr. Vetten, who talked about what she called unofficial layers of hierarchy in the court system, and that the power that a judge president would have to comment informally, for example, if asked about a secretary's performance or if they were any good. So an informal comment, even if he wasn't doing a formal performance review of her, for example, an informal comment to another judge may well have had very serious consequences for her. And the respondents tried to suggest that despite all of that, there was no power imbalance. They say Ms. Mbenenge is an adult. They say in their heads of argument, she's outspoken, she could stand up for herself. They even say that she was set in her ways. But we all here know, we work in a court system. We know that the judge president is not just some other employee in a court. He is the judge president. He's the head of court for that whole division. Particularly this judge president, who we know from his own evidence is well respected in that province. So there's a clear undertone that's worth mentioning, that in the case advanced on behalf of the respondent, there's a clear suggestion that if a woman is on the receiving end of sexual harassment, she must speak up, she must rebuff the perpetrator, and she must move on. And if she doesn't, then she's consenting to this. And that, the argument goes, is whether she stands to lose her job, whether she may be attacked physically, whether her life may be in danger, whether she may be hurt in other ways, whether she will be forced to bear the consequences of saying no. How Ms. Mbenenge may have responded to some person in the street or in a bar or in a restaurant who said these things to her could never have been the way that she responded to her judge president. That we must accept as so. Women, Ms. Vetten says, are not always able to say no. They're not always able to say no to a boss, to an elder, to someone who wields power and demands respect. We all witnessed the respondent's testimony. We saw his demeanor.
Just in passing, you say they are not always able to say no. If they don't say no, how will you know they are saying no?
The way you know that someone is saying no is you look at the objective facts, you look at their conduct. Where a judge president asks someone on the first day that he's engaging with her.
Where the objective look does not provide the answer or gives an opposite answer.
In this case, the objective facts show that she said no.
My question is where the objective test does not show a no.
Yes, if objectively you think that there was no rebuff, then sure, then there's no sexual harassment. But we submit in this case, there are so many instances in which she said no. In fact, she said no, I counted 13 times. But this tribunal cannot ignore the evidence of the expert. This tribunal cannot ignore the fact that women do not respond in the same way to every situation. I know this as a woman in the profession. A junior colleague is able to respond very differently to the way that someone in my position can respond. The same is true of Ms. Mbenenge in a court system. So we witnessed his testimony, the judge president's testimony. We witnessed his demeanor. We witnessed his cross-examination. This is not someone that's easy to stand up to. It may be easy if you're a judge or if you're a senior counsel. It is not if you're a secretary in that court. So it's imperative that this tribunal appreciate that nothing about how Ms. Mbenenge chose to react or how she reacted in that situation that she found herself was simple. She told you that in her evidence. She said, these were the things that were concerning me. He was my boss. I was scared of what might happen. She also said that she tried different ways to rebuff him. She said no. She ignored him. She refused to give photographs when asked. She got sarcastic from time to time. And she said, I asked her specifically, why did you engage in sexual banter with him? Why did you respond to his sexual questions? And she said she didn't know what else to do. Nothing that she had tried had worked. And she thought maybe if she engages with him, he'll leave her alone. That was her testimony. Ms. Mbenenge is not a perfect victim, but there are no perfect victims. There is no rule book for how we are meant to respond when harassed. There is no one way in which a woman responds. And Mr. Vetten confirmed that. And Ms. Vetten's qualifications as an expert on the subject of gender were not disputed. She was cross-examined on her knowledge of culture, but she was not disputed not to be an expert on gender. And this tribunal must take her expert advice, we submit, in that regard. Ms. Mbenenge was cross-examined for 4 long days. She was on the stand for 10 days. She's a strong woman, and she's resilient. That's true. But strong women are sexually harassed every single day in this country. And to suggest that because she had an opinion and that in the right circumstances she was not afraid to voice it. In the respondents' heads of argument, for example, they say she felt comfortable enough moving the photograph of the judge president from outside her office. That made her bold. To suggest that because she can do all of those things in those contexts, that means that she could not be sexually harassed in this context. It's an unacceptable contention, with respect. And it's one on which our courts have already opined on, that experts on issues of sexual harassment have long recognized. And it's a dangerous argument with respect, because it effectively says that only the perfect victim can be harassed. It says a perfect victim must be sufficiently meek and mild. She must also be strong enough to reject any advances outright, even from a superior and with someone who has power over her, and even when her job and livelihood may be at risk. So that victim does not exist. What does exist is the fact, as I've said, women behave differently in different situations, and that's why the objective test is what is relevant. That's why we say you must look at these WhatsApps as a whole. It's very important that one does not take WhatsApps out of context, that one looks at these WhatsApps from start to finish, and that one reads the conversations as a whole. And when one does that, one sees that there is a pattern to the behavior of the respondent. There is a pattern of persistence, there's a pattern of starting off by talking about work and then moving into sexual conversations. There is a pattern of not taking no for an answer. When, on several instances, Ms. Mbenenge refused to respond, and despite her silence, the respondent responded with the listening ear emoji, or twaka, silence, he said to her, as in, where is your response? So whatever she did, the respondent would not leave her alone. And we submit that when this tribunal looks at her conduct and questions why she responded in particular ways, you must not look at one line. You must look at the whole conversation. And you must see that it is correct that she, and I'll come to this in due course, she never initiated a single sexual conversation, not one. It's there in the WhatsApps. Ms. Vetten confirms it. Dr. Docrat confirms it. Not one instance of sexual conversation was initiated by her. And I'll come back to that in due course. So we submit there's an undeniable, clear power imbalance between the complainant and the respondent, and that the respondent exploited that imbalance to sexually harass the complainant. To suggest otherwise would be to ignore not just the jurisprudence of our highest court, such as McGregor and the Constitutional Court, but the views of the experts on gender. And mostly it would ignore what all of us working in a court environment know to be true. Chairperson, I'm about to move on to a new section. Would it be convenient to take the lunch adjournment now? Okay.
Yes, I'm just wondering, is the food nearby? Maybe we could come back at 2:15. We'll adjourn until 2:15.